Hello, everybody. Glenn Tate here with the Law Society. Thank you very much for joining us for this practice update. I'm very excited to have Beth Aspinall with us. She's one of the practice advisors with the Law Society of Alberta. And she's going to be speaking today about practice updates from through the eyes of the practice advisor, focusing particularly on technology and the soon to be coming out harassment and discrimination changes to the Code of Conduct. And those of you who pay attention, you will have seen we circulated those some time ago and solicited comments, and they're now working their way through the Federation process. Before I turn things over to Beth, a couple of logistical things. I'll be moderating this session, and so if you have any questions, please use the chat function, and then I'll be able to pass them on to Beth. Secondly, we are recording this session, and the recording will show up on the Law Society YouTube channel. Beth did mention that this is her YouTube debut, so good for her. Beth has a PowerPoint deck, and we will try to put that up with the YouTube presentation as well. And if any of you want copies of it afterwards, just let me know. And finally, if you could, please keep your mics muted so that we don't get any background noise. So Beth is a practice advisor, as I said, with the Law Society of Alberta. She's been there since the spring of 2016. Late in 2017, she also took on the role of Equity Ombudsman for the Law Society of Alberta. And as such, she advises members on practice and ethical issues and is involved in equity initiatives at the Law Society. She's a member and past chair of the Law Society's Equity Network, which is a committee of the Federation. And in that role, chaired the subcommittee which prepared amended provisions to Rule 6.3 of the Model Code. Those are the harassment and discrimination rules that we circulated and which are, as I said, are working their way through the Federation process. She's a member at large on the Canadian Bar Association's Alberta SOGIC section and previously on its national section. And prior to joining the Law Society, she practiced at JSS Barristers in Calgary for 14 years with a general litigation practice focusing on privacy, professional negligence, and regulation. So we're very excited to have Beth here. As you know, we typically have an in-person session with the Alberta Practice Advisor each year. Of course, we can't do that, so this is the next best thing. Beth, over to you.
Thank you. Okay, I'm just going to share my screen. Glenn, it's coming up that you've disabled participant screen sharing.
Try that.
There we go. Okay. I'll try to. Okay. Hi, everyone. Thank you for asking the practice advisors to present to you. We really appreciate the relationship with the lawyers in the Northwest Territories. I'm going to apologize in advance. We're still working remotely. The Law Society, we've now been out of the office for a year. And my dog, my dog seems to have really great timing. She knows when I'm in a presentation or a meeting and she starts to bark or come and hang out or something. So I apologize in advance if she gets disruptive. So as Glenn said, I'm going to focus my conversation with you today on a couple of things. Mostly technology, for the reason that we're seeing a lot of technology right now. It's really had an impact on practice in a critical way, and also just very briefly discussion of the Rule 6.3 amendments and why those are something that the Federation is working on and what's happening there. Legal practice is, of course, moving in the direction of progress, and never more so than over the past year. Over the past year, it seemed to hit warp speed. As you know, we've had to adapt how we do things. Madam Justice Woolley, who's a Justice of the Court of Queen's Bench of Alberta, commented this year that the government had a 10 or 15-year plan in terms of technological changes that they were going to implement at the superior courts, and that time frame was compressed into the span of a few months. And the court has done a great job of hitting a lot of milestones or long-term targets, and there's still a long way to go. I've been in constant meetings, and certainly the Alberta courts some of the problems and issues that people are having, but hopefully they're working out some of the wrinkles. So hopefully some of the information I can give you today is more about general practice than it is about how you actually go about filing something at the courts. If you have any questions that are related to anything in practice outside of technology or Rule 6.3, please ask them. I'm happy to answer your questions. I've put my email address in the chat function there, so that if you'd like to email me after the presentation, you're welcome to do that too. I'll try to keep an eye in the Q&A as I go, so that if there are questions as I'm going along, I can answer them, but it may be easier if I answer them at the end. I'm not ignoring you, I just probably haven't seen the question come up. Or Glenn, if you want to interrupt me if there's something, that's fine too. Okay, now if I could figure out how to slideshow this. I tried to do this beforehand, sorry everybody. Okay, so competence is always the starting point for practice updates. It's really the root of our work as lawyers. It's founded on ethical and legal principles. The rules in the code address the ethical principles, which are enforced by the regulator, but the courts, of course, can enforce the legal obligations as well. For example, if a lawyer is found negligent, that's a breach of the duty of care, and is in a sense perhaps a finding that the lawyer lacked competence, but not necessarily so. And the opposite is also true. A regulatory complaint isn't necessarily a finding that the lawyer has been negligent. So one call I often get from lawyers is, do I have to report myself to the Law Society, because I've made a mistake on a file and I'm having to deal with the insurer? And the answer is not necessarily. Sometimes, but not always, that's the case. So what exactly is competence then? This is the definition from the code, and you'll see that it's very broad. And if you're probably familiar with this definition, but it's a good reminder to look at what competence is. It's broader than knowing substantive law. It's more than understanding legal principles. It involves adequate knowledge of practice and the procedures by which the legal principles can be effectively applied. So think of this example. In my practice as a civil litigator, I was happy to go to court. I enjoyed going to court, but I wouldn't do it for the sake of going to court or being aggressive or putting the screws to somebody. And I did have a client who wanted to adopt a scorched earth policy. Let's go to court. Let's delay everything. Let's slow down the proceedings. Let's really push the opposing client. Let's really push the opposing lawyer. And I had to examine not just my own comfort with that, but my own competency. Like, is this within my competency? And I ultimately decided, no, I'm not competent of acting for this particular client. And I sort of referred him to another lawyer at my firm, and they were quite happy to work together. We have a duty to be wary of providing unreasonable or overconfident assurances to our clients. This is a recent development in the commentary to the rule, which is Rule 3.1-2, again in the Model Code, not yet adopted by the Law Society of the Northwest Territories. That's a very recent amendment. An additional element is that a lawyer should only express their opinion when it's a genuinely held opinion and it's provided to the standard of a competent lawyer. So this means don't just rubber stamp things or justify a course of behavior when there isn't a legal basis supporting your opinion. In some respects, this means that as lawyers, and this is never something we're comfortable with, but it means maybe getting comfortable with saying, I don't know. And of course, competence involves the use of technology. You could see in the rule there was nothing that says you must be competent in your use of technology in your practice. The Federation amended the Model Code in October 2019 to include the requirement to be technologically competent. It's been adopted in Alberta as of February 2020, not yet in the Northwest Territories. But remember that the Code of Conduct is an aspirational code. It's not a complete code. And so that means that the definition is very broad, that definition in Rule 3.1-1 that was on that earlier slide. And it means that technology as part of practice has to be used competently. So lawyers are required to develop an understanding of and ability to use the technology that's relevant to the nature and area of the lawyer's practice. What that really means is understanding the risks and the benefits associated with using technology, and in particular, the impact that the technology has on confidential information. As lawyers, our duty really is, our primary duty, so much revolves around this duty of protecting client confidentiality, and that will hinge very much on technology. So what competence is as it relates to technology will depend on practice area, geographic location, because I'm sure with practicing in the north, internet is probably not as great as it is in Alberta, as we know, or in some urban centers. And so those are elements that go into the analysis of what is competence when it comes to using technology. And for example, if you have a really complicated civil litigation matter with thousands of records, you should consider whether you need a record production program. You likely won't need a suite of software to produce records for a small litigation file. And that's even with current requirements to submit records electronically or to produce records electronically. So while you don't have a code provision which expressly sets out the requirement to be competent in your use of technology, that doesn't mean that you don't have to be competent in your use of technology. It's not yet explicit, but the principle is still there. The American Bar Association, we often turn to for guidance. They have a different culture for certain, but as practicing lawyers, we face many of the same issues. And because they are So if you think about for a moment the example of a sophisticated client, maybe in a takeover, a share purchase, that client has highly sensitive information. They've taken steps to protect it within their servers. The lawyers need the information too, and so the lawyers are often less secure than maybe some of those larger corporations. So the lawyers house the information on their systems. If I'm a cyber attacker and I think, well, I could attack Fort Knox or I could attack this firm that doesn't have the same security measures, well, I'm of course going to take the weaker link. And from the calls we've seen to the practice advisors, lawyers are experiencing cyber attacks. They are having their systems hijacked by cyber attackers. And while lawyers were initially slow to respond to the threat, it's better now, or it was better before 2020. 2020 has seen another rise in attacks. I read one statistic, this isn't lawyers alone, but in the United States, I think it was, cyber attacks were up 300%. So cyber attackers are out there, they're taking advantage of the fact that people are working remotely. So you know that the training isn't as consistent, communication between staff members isn't as consistent, and there are vulnerabilities that are being exploited. These are the topics that I'll look at today. I'm not going to spend any time on the second one, crossing the border, because it's just less relevant right now, but know when things return to more normal that crossing the border is an issue if you have, if you're taking a device with you. But if you have specific questions about that, of course, please ask. And so speaking of competence and cyber breaches, you don't want me speaking to the specifics of how to prevent a cyber attack and how to respond technologically. Part of competence means having a solid IT team or person who can answer those questions and help you put security in place, put training in place, and also respond if you are unfortunately subject to an attack. So if you are the subject of a cyber attack or a victim of a cyber attack, what should you do? One of the things you'll have to do is notify people who are impacted by the attack and the subsequent breach. try to examine who in your system has had information taken. And that goes beyond clients. As lawyers, we tend to think clients because we're so focused on privilege and confidentiality. But the test in the privacy legislation is whether there is a real risk of significant harm. So if there is such a risk, you will have to report to the Privacy Commissioner. And one of the things you can do early on to manage what happens with the Privacy Commissioner is to report to everybody who's had information that was impacted. So if you have a cyber breach, it's likely it's broader than clients. So think about the non-clients, opposing lawyers, experts, vendors, etc. Make a list, contact those people, and then when you're contacting the Privacy Commissioner, you're in a better position. I say in the slide, report to CLIA with a question mark. You should check as to whether CLIA covers losses arising from cyber breaches. ALIA does not. So in Alberta, our professional liability insurance does not cover cyber breaches and losses arising from that. I couldn't find the CLIA policy online, so I couldn't check, but you should turn your mind to the fact that you may need independent coverage for losses arising from cyber attacks.
Beth, it's Glenn. We have cyber coverage, but
okay,
the advice we
perfect.
pass on to our members as well is that they should make sure that they've got sufficient cyber coverage. The coverage we have might not be sufficient.
Right. Okay, great. That's great to know. It's been a huge source of conflict in Alberta that ALIA does not cover. So it's nice to hear that you have it. The Law Society does have an arrangement in Alberta with Beasley, and so they're familiar with lawyers' needs. And so if you're looking for additional coverage, that's one place to start. And one thing the practice advisors have seen is people who do pay the ransom when they're subject to a ransomware attack. And firms, small firms in particular, seem to be quite vulnerable to ransomware attacks. And the ransom is fairly small, and often the firms will say, I just need to get back in business. It's easier to pay the ransom and then move on. The difficulty is that sometimes the attack will embed another virus in your system. Sometimes they'll have stolen information from your system. So even though you pay the ransom, they then publish confidential information. So before you pay the ransom, contact your insurer and also your IT professionals to get some help in terms of what's been released, if anything, and what you need to do. And as an example of a law firm who was subject to a cyber attack, this is a UK firm, so it's not in Canada, but it gives you the idea of what firms are potentially facing and that this is real. This was reported to the Information Commissioner in the UK. They looked into how the data was so easily accessed from outside. And one of the findings is that the Information Commissioner made it clear that even where a data breach is a result of a malicious cyber attack, that's not an adequate defense over data protection and serves as no excuse. And they go on to say the sensitive data should have been encrypted and never associated with any form of external web application. Apparently the information was accessible through the web. So how it was housed was a problem for this law firm. And one thing I will advise, this is a question I get fairly frequently, is about Dropbox. Clients like using Dropbox. Lawyers like using Dropbox. Beware of Dropbox, and in particular, be aware of the free version of Dropbox. And when I say beware of the free version, what I mean is don't use it. The professional version is fine, but you don't have a choice as to the jurisdiction where the data is housed or stored. That's only available with the paid version. The free version has a strong limitation of liability, and it's also not intended for business use. So in the UK, a law firm that used the free version for business use was subject to regulatory action for a data breach, a data protection breach. Like I said, the professional version, is fine. You have more control over where the data is housed, it's encrypted. In this case, the ACS, just going back to that for a moment, they were using, I believe, the free version of Dropbox, and the firm's security measures were described as barely fit for purpose in a person's home, never mind in a business handling sensitive information. Practice management at the Law Society of Alberta recommends sync.com, which is sync.com. That is a Canadian provider. It encrypts all the documents before they're uploaded to the cloud. And the staff at Sync never get the de-encryption key. So they can't share the contents, even if a subpoena or a hacker gets in. The cloud, and of course, it's not a surprise to anyone that the information is not stored in the cloud, that it's on the ground somewhere. The servers exist. Where those servers are can exist a lawyer's obligations for competence. One question practice advisors often get is whether lawyers can use the cloud for storage. Yes, absolutely yes. Like I said, just be careful of who your provider is and do your research and your due diligence, and I'll come to that shortly. In Alberta, in 2016, when the fires happened in Fort McMurray, one of the firms that was most successful in recovering from that, their office was caught in the fire, but their servers were cloud-based, and they were able to go to Staples, buy a couple of laptops, go to a hotel room, attach to the internet, and they were set up and they were ready to go and in business. Whereas the firms who had their servers in their offices didn't fare so well. So the cloud is absolutely appropriate and a great tool. That said, competence and therefore ethical and reasonable use of the cloud requires some knowledge. You should have some information about your service provider to ensure that the information is secure and protected. You also need to turn your mind to what happens if the service provider goes out of business. How will you as a lawyer engage the service, retrieve the data, that kind of thing. And this sounds hypothetical, but it's actually not. We do receive calls about this. And there are service providers who are a bit more fly-by-night. So try to find someone who's established and reputable. These are some of the key elements of your contract with your vendor. So knowing that they don't have interest or ownership in your data, that they have an enforceable obligation to protect security, and that they'll give you notice. If they receive some request to go into your data, that they give you an opportunity to respond before they do that. Previously, we had understood that accessing data was regulated solely by the laws of the jurisdiction where the servers were housed, where they were resided. So for example, you could hire Microsoft, and provided Microsoft had their servers on Canadian soil, it was fine. There's recently a decision out of the American Supreme Court that changed that. And that says now that if your servers are not on American soil, but they're owned by an American company or an American subsidiary, they are subject to American legislation and regulation. So the Patriot Act and the Cloud Act they're concerning. They give the American government considerable ability to go into your servers and get data. And of course, for lawyers, that's a concern because of privilege. So one of the key things you can do when you're working with a vendor is find out where the servers are housed and what the nationality of the company is. And really, with vendors and cloud computing, and not just cloud, I mean, any of your technology, it comes down to knowing what your service provider does. With cloud, how do they encrypt the data? Who can access it? Those are your key elements. This is a bit of a repetition, but that's how important it is. Metadata and web bugs. I had never heard of web bugs until a couple of years ago. Apparently they've been around a while. We're starting to see them in practice as much as they can be seen because they're a bit of an invisible thing. Both of these tools give a person information about another person's use of a document, and they both do so in a way that is hidden. So most of us are familiar with metadata. So every electronic document contains some sort of metadata. So this is information about the document, right? So if it's about an email, metadata can give you information that you might not otherwise have, or importantly for lawyers, information that you're maybe not entitled to. For instance, when a document was created and by whom, the revision dates, document file paths, usernames, text revisions left behind on the track changes feature. So if you think about that last one for a little bit, as a lawyer, text revisions left behind in track changes, that kind of information could well be information that is information between the lawyer and client, part of their discussions and part of their strategy on a file. So if you're accessing the metadata, it could be privileged information. So as a receiving lawyer, you can get information about the other side's strategy from this kind of information. And I'll come back to this. Web bugs also provide access to that kind of information. Through web bugs, the sender of an email can track when the email was opened, how long it was reviewed, whether it was in the foreground of the screen or the background while the user worked on other activities, how many times the email was opened, if it was forwarded, who it was forwarded to, the approximate geographic location of where it was forwarded. So there's a lot of really valuable data in the metadata and in the web bugs. Ethically speaking, there are two sides to this coin, both that of the lawyer sending the document electronically and that of the lawyer receiving it. And both have an ethical obligation vis-a-vis the metadata in the document. The sending lawyer should take steps to clean the document, clean the metadata from the communication. And again, speak to your IT professionals on how to do that. And the receiving lawyer shouldn't go looking for it. If you do see it, treat it as an inadvertent communication. If you need to go into a screen and the metadata comes up, approach the problem as you would under any other inadvertent communication under section 7.213 of the code. Advise the sending lawyer you've received it, and delete it from your deleted items. If you've already sent it on to your client, get your client to delete it and confirm that they've deleted it as well. And as an example of metadata, and a problem it can create for a lawyer. And I've actually received this call or a version of this call a few times, is using a precedent or using a client document as a precedent. So this lawyer had an agreement and she took out client names, put new client names in. In fact, I think it was even her own agreement. And she sent it over to the party on the other side, who turned out to be a vexatious litigant. And so, of course, not somebody easy to work with or manage. And that person went in, found the metadata, called the lawyer's client, who was listed in the original agreement, and started threatening that client. So metadata is there, it's real, and it's important to take steps to protect your client and your client's information. Okay, so back to web bugs. Web bugs are really tracking devices, and so if one lawyer uses them in communications with another lawyer, really, in essence, that lawyer is seeking to get privileged information, trying to get information that they wouldn't otherwise be entitled to. That is, of course, not an ethical approach. It's an unethical intrusion into the solicitor-client relationship. And I get frustrated because there's different versions of web bugs. There's different types, and even I'm getting emails that have web bugs attached to them when lawyers are sending them to me. You can speak to your IT people as a way to deal with web bugs. The reality is that the technology changes so quickly that it may be impossible for a receiving lawyer to implement some kind of a fix to block tracking software. The only reasonable means of protecting solicitor-client communications from web bugs is to address or regulate and bar a lawyer from using them. And I have had calls from lawyers where they've somehow inadvertently or stumbled on the fact that the lawyer on the other side of the file is using a web bug and has got all kinds of information about their management of the file and their communications. I'm not even clear how they got that information, but we do know it's happening. Lawyers are using it. And of course, admittedly, we don't have a specific provision in our code to address this particular circumstance, but we do have the provisions protecting privilege and also protecting inadvertent receipt of communications. But I think web bugs, these kinds of deliberate tracking devices, I think that's more than an inadvertent communication. I think that's a deliberate effort to get at the metadata, right? Or worse, or more, right? So it's I think a fairly serious transgression, and even, you know, the web bugs I've received, I click on something and it says, great, thanks for clicking on this, a notice has been sent back to the sender. Even those, I think if you're using that, you have to look at why you're using it. If you're using it in the context of a litigation file, I'd recommend you get advice and direction from the court before you use it, just so that you're above board. Try not to use these things as the normal course. Portable devices. All of the steps on the slide are important steps. No one mechanism alone will help you. And in particular, and I know that photocopiers are not portable, and I know that in the past year, a lot of firms are understanding how much they do or don't need photocopiers anymore. But photocopiers can also store information. So depending on the type you use in your office, if you come to the end of your use with that machine and decide to sell it or your lease is up, remember to wipe the memory the same way you would if you were disposing of a computer. The other point I want to emphasize is memory sticks. At the Law Society, our standard is that we have to use encrypted memory sticks. They're so easy to lose, right? In fact, I lose them all the time myself. If it's encrypted, nobody can access the data that's on those memory sticks. Also on the topic of memory sticks, this may be common knowledge, but cyber attackers are known to use memory sticks to attack a system. So if you ever find a memory stick somewhere, don't put it into your computer. You know, I think people think they're doing a good thing and they can find it and return it to the person who's lost it, but it could be a planted virus. So just throw it away is the best approach. And then the etc. Each of these is a potential trap for lawyers and breaches of confidentiality, so be cautious in your approach to them. Email, we've known for years that email it's like postcards in terms of confidentiality. And the best practice is not to send sensitive materials by unencrypted email. You know, it's easier now than it has ever been to access an encrypted email service, so use encrypted email. I can tell you I had a call a couple of weeks ago from a lawyer who had received instructions. They working on a corporate deal and received instructions to issue funds that they were holding in trust. And the lawyer accepted those instructions and issued the funds from trust. And as it turned out, the client's email system had been infiltrated by a cyber hacker, and the instructions that the lawyer followed the money was gone. It wasn't the client. So when you receive instructions by email, confirm them in a way that is not email. So whether that's phone or fax, something else. Even another email on the same system isn't secure. If they're into your email, they're probably into your firm's email. Social media, we're seeing a lot of reports of inappropriate use. Lawyers are using social media to advertise, and that can be great. It's not prohibited, but you have to be careful about if you're talking about a particular file or a particular matter, particular client. If people can be identified from that, that can be a breach of confidentiality, and it could be something that the regulator takes issue with. Siri Home. Actually, this is interesting because this has been on my radar for quite a while, and I think people think look at me skeptically. I actually received an email yesterday from the American Bar Association where this continues to be a problem, where those devices record information in the background. Well, where does that information go? And as an example of how this has been used, I mean, this isn't lawyers, but it'll give you an idea. There was a person was accused of murder or manslaughter. This was in the US, and claimed they were innocent. They were able to get the data from the home recording device that proved it wasn't them. So those things are on in the background. They're taking in data. If you're working remotely and you have that in the background. I mean, I think for me, I don't have it, but if I had it, I think of the phone calls I have every day with people. If one of those devices is recording those conversations, that's a problem in terms of confidentiality. Recording phone calls. This has been, it's been quite prolific during the pandemic, where people are recording phone calls, or even on, say, WebEx or any of these other platforms where they go in and start controlling or recording without necessarily telling the other parties. Be aware of your obligations. The code indicates that you can't record another lawyer or client without their advanced consent. So be aware of that and be careful about it. We also know of phone systems that automatically, firms have set up the phone systems that automatically record every call that comes in. Again, be careful of that, as lawyers probably shouldn't be using that kind of technology. I'm just going to pop into the chat to see if there are any questions. Okay, yeah, your code, I guess, isn't up to date on the web because you have adopted all those changes on technology. That's great. Cloud storage on, the question is, would cloud storage on EU servers comply with practice requirements that GDPR is considered to be stricter privacy regime than the one that exists in Canada? I think if you've done your homework and you've figured that out, that's acceptable, right? Like, it's all about doing the background checks, figuring out what the system is, what the protections are, but also knowing, you know, I mean, we know that American servers are an issue. See if there are issues in terms of European ones as well. Okay, so moving on from technology then to the Rule 6.3 amendment. As Glenn mentioned, of course, and as you know, the Federation is in the process of reviewing section 6.3 of the code, and that's the harassment and discrimination rule. Alberta in 2019 did a survey of articling students and lawyers who were 5 years or fewer at the bar. And of course, we learned that I say of course because I suspect you may have heard already, we learned that 1 in 3 articling students experiences harassment or discrimination. And this is a problem, a big problem that we're trying to address. In Alberta, we've done a few things, and we're continuing to do the work to improve. Well, improve is the word, but implement a system change, essentially change the direction that we're heading in to make practice safer, more diverse. Our current rule is not very good. This is it in its entirety. So such a serious and difficult subject with such far-reaching consequences has such a very small rule, and frankly, an ineffective rule with internal contradictions. We know harassment discrimination is a problem in our profession, and a key element of that change and the change that's needed is in the code. So the 6.3 amendments, of course, the consultation process was ongoing. I think they initially thought they would have that completed by 2020 and be looking at either amendments to the amendments and adoption, but I don't think they're even close to that now. One of the big issues is bystander reporting. Under Alberta's occupational health and safety legislation, and also the federal, I'm not sure, Northwest Territories, what your specific rule is, but there's a requirement if you see somebody else being harassed or discriminated against, there's a requirement to report that. Of course, that creates a problem in law, where if you think about the example of maybe an associate who's being harassed by a partner, and that's seen, observed by an articling student, if you have a bystander reporting obligation, that puts a huge obligation on a student who's already very vulnerable. So I do encourage you, Glenn mentioned that the amendments went out for consultation. I do encourage you to be part of that process, to share your thoughts and your understanding based on the experiences that you've had. The process is ongoing, change is coming, but we really need to think about the change that we need to see in the profession and how each of us can contribute to that better workplace and better diversity within our profession, and supporting our colleagues too. So that's all the content that I have planned. If you have questions, I'm happy to answer them. And here's our contact information. I've put my email address in the chat as well. You're welcome to use that. If you go to our website, you can send a message to Jesse McKenzie or Alan Rudy as well. They're great practice advisors. We're really busy. We've had in the past year 6,000 calls. So between the three of us, we're busy, we're managing a lot. And I noticed that my assistant here has put a note on my slide about this is a good opportunity to touch on what is and what isn't time sensitive. Right now, we're endeavoring to respond to calls within 48 hours. That's subject to staff absences from the offices and holidays, that kind of thing. We're doing the best we can. We're finding that that's resulting in a lot of people saying, well, it's urgent, it's urgent. It's actually, urgent is I need an answer within the next 24 hours or the bottom is going to drop out of whatever it is that I'm working on. So if you're in that urgent situation, please call or email us, tell us that it's urgent, and we'll prioritize you so that you're getting a call back, hopefully same day. So that's everything I have planned. I'm happy to answer questions, or if anybody has any comments, anything they'd like to discuss.
Thanks, Beth. There was another question that popped up, which is there specific encryption software recommended for USB sticks? Is there something that you could recommend?
Do you know, all I can recommend is what the Law Society of Alberta uses, which is, I believe it's called Kangaroo. I'll look into that and I'll send it to you, Glenn, and I'll talk to our BT people on that too, and I'll send you that answer.
Great, thanks. And we don't in the NWT have the same kind of bystander legislation that you were speaking of in Alberta, or we don't have it yet anyway.
Okay.
But I don't think that takes away from your point at all, though.
Yeah, bystander is difficult. It's when I saw that come through in Alberta's occupational health and safety, it's a way of forcing transparency, but it can really create more victims in a bad situation. So it's I don't think it's an easy solution. I don't think it's necessarily a practical solution either.
All right. Are there any other questions that anyone has? If so, can you send them on to us and we'll pass them on to Beth? I know as well that when the practice advisor used to make personal visits, we set time aside for individual consultations. And Beth has said, and I will repeat, that her and her colleagues are always ready to talk to you about anything. You have the phone number there. You have her email in the chat. You have the website there as well. We encourage you to call with your practice questions. We get practice questions here, and some of the simple ones we try to answer, but otherwise we simply say, why don't you phone the practice advisor, because they likely have a much better sense of this than we do.
Well, and we've probably seen it before too, if it's something unusual.
Yes. All right, Beth, I'm not seeing anything. So then okay. I want to thank you again. We really appreciate the work that the Law Society of Alberta does to support us, and particularly the work that you and your office do to support our lawyers here. It is much appreciated. And I know that of the 6,000 calls you get, a fair percentage of them come from people in the Northwest Territories. I want to thank everybody for attending. Beth, again, I want to thank you for participating. We will have Beth's slides, and we will, if you want to see them, let me know, and I'll get them circulated out to you. Otherwise, we'll be putting them up on the YouTube channel along with this presentation. And with that, I want to thank everybody. Have a good afternoon.
Thank you.